10, please take a seat. Those at the door, please take a seat. We'll start calling names in a few minutes. Little joke. So our next presenter is one of our newest justices on the Georgia Supreme Court, Justice Michael Boggs. He is going to make a presentation on the great work that's being done in the name of Georgia reform of the criminal justice system. But before Justice Boggs comes up, we are tweeting this event. The hashtag is GA Ferguson. In addition to that, if you have questions, we can't hear them when you yell them from the audience. So please use the cards at your table, write those questions down, and someone will take those questions and bring them up to the front so we hear your questions and they can be answered. Thank you so much. Justice Michael Boggs.
Well, good morning, everyone, and thank you for being here. Carlise, thank you for the invitation. I'm trying to get a little organized here. I've got a PowerPoint presentation that I want to talk about, but just give some introductory remarks first. First, thank you to the committee. I'm really appreciative for the opportunity to present the work of the Criminal Justice Reform Council. The scope of our work, we've been working since 2011. I've been co-chair of that council since 2012. We've been working now for 5 legislative sessions and making recommendations to the General Assembly for possible codification or adoption. And they've been very, very willing to assist us in that regard. None of that would have been possible without the extraordinary leadership of Governor Deal, and I want to thank him personally for everything he has done to really make Georgia a national thought leader in the area of criminal justice reform and really responsible and reasonable criminal justice reform policies. And so I want to talk about some of those policies, and I will do that this morning, but understand that the scope of our work is much broader than I'm able to discuss this morning. So I would refer you to a couple of resources. The Pew Center on the State's website contains copies of our reports and white paper summary issue briefs on the scope of our work. So I would encourage you to look at the Pew Center on the State's website. Pew provided technical assistance to us in 2012, and so they have some really good resource material. In addition, the Department of Community Supervision has copies of the reports of the Criminal Justice Reform Council on one of their drop-down menus on the department's website. In addition, I know that the Administrative Office of the Courts and the Supreme Court Clerk's Office have copies of the bench card that I think was in your materials, have copies of the bench card that was a product of work between myself and some students at Harvard University Law School and the collaboration with Judge Ben Studdard, who I know was here earlier. So understand, I cannot talk about everything today in the time capacities that we have, but I want to give you a little primer about why we did what we did. So in 2011, after the governor was elected in 2012, I want to give you some statistics, really the impetus, if you will, for why Georgia embarked on this now 5-year streak of working on criminal justice reform policies. Between 1990 and 2011, Georgia's prison population doubled to roughly 56,000 inmates. We were projected to grow by another 8% from 2011 through this year, which would have given us the 4th largest, and at the time we had, the 4th largest incarceration rate in the nation. In addition, that growth would have cost Georgia's taxpayers roughly $264 million in extra growth. Nonetheless, in Georgia, 1 in 70 Georgians was behind bars in 2011 when we embarked on criminal justice reform. That did give us the 4th highest incarceration rate in the nation, with the national average being 1 in 100. In addition, we were spending roughly in 1990 $464 million on the Georgia Department of Corrections. So not only did our population double, but our cost doubled, because in 2011 the Georgia Department of Corrections budget was $1.1 billion. For that, each bed in the prison system cost then and still cost roughly $18,000 a year. For that public safety investment that Georgia taxpayers were making, the return on that investment, as measured by recidivism from those released, Georgia was releasing then roughly 18,000 citizens a year from the prison system back into the community, and roughly, based on our recidivism calculations, 30%, so 6,000 of those 18,000 were back in prison within 3 years. And so with those kind of thoughts in mind, we looked at why was our prison population growing, and we knew, for example, that it was not because of an increase in violent crime. In fact, over the past decade prior to our work, property and violent crime and property crime had fallen 20 and 21% respectively in Georgia. In addition, we wanted to look at who was coming into our prison system at that time, how were our numbers getting so exponentially high, and we recognized that roughly 60% of the offenders in our state prison system were property and drug offenders. In fact, of those admitted in 2011, 25%, roughly 5,000 people admitted to prison in 2011 or 2010 were low-risk property and drug offenders whose predominant crimes were in the property and drug arena, and who we all know as judges, having been a former trial court judge, a superior court judge, prior to my work on the Court of Appeals, we recognized that 80% of every crime in Georgia is drug-related. And you can read the paper and you can recognize a drug case fairly easily if someone's arrested for trafficking in marijuana or possession of cocaine. What is less intuitive, I think, and less obvious to most people are the inordinate number of property crimes that are also drug-related. You just don't recognize the correlation. And so it was out of all of that as a trial court judge back in the Waycross Judicial Circuit some now years ago, in 2008, I started an adult felony drug court program to try to address the criminogenic drivers that were creating these problems and try to help people who had a substance abuse or mental health issues that were causing them to be engaged in conduct that got them involved in the criminal justice system. So with that as a background, the governor in 2011 created the Criminal Justice Reform Council. I was a member that first year, and I'll go through some of what we've done specifically. But since that time, I have co-chaired that council, and through last year co-chaired it with Thomas Worthy, who was then the governor's deputy executive counsel. Now I chair with Kerry Miller, the governor's current deputy executive counsel. And just so you know, the council is really this bipartisan group. It's not just Democrats and Republicans. It's a very collaborative, inclusive group of individuals, stakeholders in the criminal justice system, experts in the criminal justice system that are taking a real hard look at policies within the system to try to remediate and make recommendations to the General Assembly about ways to fix some of the problems, and particularly some of the outlier problems that not only have been driving Georgia's enormous prison population growth, but some of the moral imperatives that are involved in this. It's not just a fiscal imperative, it's the moral imperative. Is there a better way to deal with some of the people that we've been dealing with in the criminal justice system? And so the governor set out that we would do three things when we made recommendations. First, that our recommendations would hold offenders accountable. Every judge, every citizen believes there ought to be consequences to bad behavior. It ought to be proportional, but it also ought to help, right? It ought to ensure that an individual receives the services and the programs they need to prevent them from recidivating and becoming another problem. So first, make recommendations for policies that hold offenders accountable. Second, make recommendations that improve public safety. Let's do something about the recidivism rate. And thirdly, if we can, let's make recommendations that save taxpayer money. The governor called those the three legs of the criminal justice stool. And with those as kind of our charge, we set out in 2011 to start with the adult criminal justice system. And so you will see that if we did nothing, Georgia's prison population was indeed expected to grow by 8%. It would have cost $264 million. We would have had now over 60,000 inmates in the Georgia prison system. And we knew that some of the drivers were that 5,000 low-risk property and drug offenders were being admitted to prison in 2010. Also, nothing to be very proud of, in 2011, I believe it was, Pew issued their 1 in 30 report where they indicated that 1 in 30 citizens was under some form of correctional control. When I give this speech to Rotary clubs, it's really interesting to watch everybody turn around and look at everybody else in the room, because Georgia led the nation in 2011 with a number of people under some form of correctional control, either in prison, in jail, on probation, or on parole. We led the nation. 1 in 13 citizens in Georgia was under some form of correctional control. Nothing really to be proud about, right? So that was part of this impetus. Is there a better way to take a look at our criminal justice system? So as drivers and the impact of doing nothing. Just to give you an outline, the first year we took a look at adult reform, and I'll cover a little bit of that. The next year we looked at juvenile justice reform, rewrote the juvenile code, and addressed some really interesting school-to-prison pipeline issues that had been been out there for years, partnered with the State Bar of Georgia in some of those collaborative efforts. We looked at reentry. How can you best re-enter some of these citizens from prison into the community in a more productive way? And then in year 15, we took a look at misdemeanor probation reforms. You are all familiar with the case that arose and ended up at the Georgia Supreme Court relative to tolling, but also some of the egregious practices that were and have been practiced upon misdemeanor probationers in Georgia. So that was kind of an outline of where we were through 2015. We've just passed the 2017 session, which I've not updated yet, but we also addressed misdemeanor probation reform there as well. Here are some of the things we did. So we changed the felony threshold for burglary and theft from $500 to $1,500. That had not been changed in Georgia since 1982. So what had been a misdemeanor or a felony is now a misdemeanor up to $500 and $1,500. Not sure if you're familiar with this. Most of you would have no reason to be. But in Georgia, then, when I was a trial court judge, if an individual was caught with any amount of cocaine, residue on a straw was sufficient. The sentencing range for the judge was 1 to 15 years in prison. You could get 15 years in prison the first time, and so we thought that it might be more appropriate to move to a weight-based drug sentencing scheme with respect to those drugs, and we did that. We required clerks, upon sentencing inmates to the state prison system, and those individuals now becoming state inmates, that the sentencing packages be submitted electronically versus by mail, and you'll see a slide here in a moment that tells you exactly what that has produced. We have created some mandatory minimum safety valves. Most of the judges you talk to, I think, would tell you that they want judicial discretion. They've been elected to exercise judicial discretion. They want to be able to make the punishment fit the crime, and they don't want their hands tied. Mandatory minimums are one of the reasons we are in the position we are in. Also, we are in that position because of the creation of a 3 strikes you're out policy in Georgia, and we're also in the position we're in large part because we've abolished earned time credits. You could earn your way into prison, you couldn't earn your way out of prison. And those are the policies from the 1990s that you will all remember when folks were getting elected to public office by being tough on crime, that have kind of come back to cause some really unintended consequences. And so we, in that year, established some mandatory minimum safety valves in drug trafficking and in some sex offender cases. We've provided certificates of program treatment and completion, in essence, allowing citizens while they're in prison to earn certificates of program completion such that when they get out, it would assist them in getting professional licensing and also, in certain circumstances, provide some liability protection to their employer. We provided for conditional driver's licenses for accountability court participants. Very difficult, if you're not familiar with the onerous nature of accountability courts, to complete the onerous nature of all of the things accountability court participants have to complete if they can't drive. And so we provided judges the discretion to provide limited permits. We looked at expanding parole eligibility for nonviolent drug recidivists. So to give you the hypothetical that I've used in many speeches in Georgia, assume an individual, Susie, has 3 prior felony shopliftings before we changed the threshold. So that would have been $300 or more in felony shoplifting. Her 4th offense is a 1613-32B, possession with intent to distribute marijuana. The judge in that case, based on her history of 3 prior felonies and based on her new offense under Title 1613-32, would be required to give this young lady the maximum provided by law. The maximum provided under that statute is 10 to 30 or life, which means life. As if that is not egregious enough, because of the way our recidivist sentencing statutes work, that is life without parole. That is life without parole. Now, you murder somebody in Georgia, and if you don't get the death penalty or life without parole, you are eligible for consideration at 30 years. The hypothetical I just gave you, we had people sitting in prison with those sorts of situations that were never going to get out of prison. They did not have a serious violent history, criminal history. There had never been anyone harmed. In many instances, never been a gun involved or a weapon involved in any of those prior 3 felonies. Yet, the way the recidivist sentencing statute worked, that was going to be the outcome. And so we endeavored to take a look at carving out some of the non-violent, non-ringleaders, if you will, some people that were lower level offenders, low risk to reoffend, and gave them an opportunity, if they had done everything institutionally that they were required to do, get their GED, not be a disciplinary problem, and get disciplinary reports while they were incarcerated. And they took advantage of programming, took substance abuse and mental health counseling if it was appropriate. Under certain circumstances, they could apply to the parole board for consideration for early release. And we know I went and met with the first one that was released to Bibb County. And went and met with that young man when he was released. He was the first under this new law that was allowed to get out. He had served at that point 17 years and would not have gotten out but for that change in statute. Now we're all hopeful, right, that we're right about who these people are and that they are low risk, they are nonviolent, and they will not make a mistake, but everyone's capable. And so what we did is we took a look at that and we changed some statutes giving the parole board permission to take a look at it. In addition, we capped the length of stay at probation detention centers. We created some pre-sentence assessments that were going to allow judges to be a little bit more precise with their dispositions and sentences. We created some day report center light programs. We created a probation options management program which allowed people to get out from under the daily grind of reporting to a probation officer on a regular basis, and as long as they were compliant, they could report and have their matters, whatever matters they are that were violations of probation, resolved outside of the judicial system with their permission. You can see at the bottom the appropriations. You know, it's always said that if you want to see what is in a person's heart, take a look at their checkbook, right? It's probably pretty good advice. If you look at what the Georgia General Assembly has done since 2011, appropriated some $20 million plus for expanding and strengthening accountability courts in Georgia, cobbled together $5 million in state money and $1 million in federal dollars to create a fiscal incentive grant for juvenile justice. I'll talk about that in a moment. Put $10 million a year for education, technical, and GED training in the Department of Corrections. I'm not sure if you know this, but you know, in Georgia, you can get a GED while you're incarcerated. You all probably were aware of that. But how many of you were aware that you can now get a high school diploma while you are incarcerated in Georgia? The reason you don't know that is because it's new. But Georgia now has a charter school in its state prison system. And you're able to get a high school diploma, and you know the difference from an employer's perspective. They're going to give someone with a diploma maybe a little bit more opportunity. So those are some of the things that we've done specifically in the adult arena. That's a real hard look at what our Georgia prison population has been. The green lines coming down are the bills that got passed in adult reform starting back in 2012. So when we started, we asked the General Assembly to put together all of our recommendations. Those were included in House Bill 1176. At that time, Georgia's prison population was 54,895. We're down now to about 52,177. So some of these policies are responsible for that. I don't take credit for all of it. There are changes in cycles of criminal conduct. There are all kinds of things that are attributable to ebbs and flows in your criminal justice system and in your prison population. But some of the things we have done have been directly attributable to reductions in prison population. Here's our jail population, so you know the difference between jails and prison. And county jails, when we started in 2011, were at 92% capacity across the state on average. They had 41,628 individuals sitting in county jails. Because of some of the policies that we've enacted in House Bill 1176, House Bill 349, and Senate Bill 365, you'll see that in March of 2016, we were down to a jail population of 35,907, which puts us at 75% capacity. So we've freed up a lot of county jail beds, which has its own consequences as well, but just know that that's part of the process. Who are the people going to prison? The commitments, people every year going to prison, because that'll tell you what your population is going to be. And you can take a look here that our commitment high point was around 2009. But look at the drop, precipitous drop in the commitments to prison. So in 2015, we sent 18,139. We're below that now. But look at what's in the middle here with the star. In 2015, Georgia saw the lowest number of overall commitments to prison since 2002. We're not sending as many people to prison. I think you might find that the reason for that is because we've expanded accountability court and diversion programs. We've recognized that some of the drivers for these low-risk nonviolent property and drug offenders can be more readily and appropriately, fiscally and morally addressed in an accountability court program than in the state prison system. And so that is, I think, byproduct. But I was interested in the racial makeup of some of these commitments too, and I'm going to show you the next slide, which I think you will find particularly interesting. So here is the racial composition of prison commitments from 2009 to 2015. And I'm going to read this last portion to you. So while the overall prison admissions in Georgia have dropped 16.3% between 2009 and 2015, the commitments of African American men dropped 24.3%. The commitments of African American women declined 37.6% over that period of time, such that the number of African Americans entering the prison system in 2015, which was 9,983, was its lowest since 1988, which is incredible if you think about really the efforts that we're making. And it's because a lot of those commitments were low-risk property and drug offenders that, but for other options, were being sent to prison. And we know that prison wasn't working because we know we were spending $18,000 a year and we had a 30% recidivism rate. There's your recidivism rate reductions that you've seen in Georgia since 1972. So you can see high point of 40% recidivism back in the 80s, which is probably what prompted a lot of the tough on crime policies that I mentioned earlier. And you can see that at the end of 2012, the recidivism rates were around 26.4%. So recidivism rates in Georgia are judged by a 3-year look back on whether or not during the 3 years subsequent to an individual's release, whether they have been reconvicted, not rearrested, not recharged, but reconvicted of a new felony offense. So I told you the jail backlog. I mean, the jails were now at 75% capacity, and what you'll find is that because we've instituted a couple of policies, one is we've capped the amount of time an individual can spend at a probation detention center, and because we've instituted electronic submission of sentencing packages, we're expediting the Department of Corrections coming to county jails to pick state inmates up, that is post-conviction, post-sentencing. And so you can see the jail backlog. People are not sitting in county jails nearly as long as they used to be sitting in county jails. They're being transferred. And that's important for a number of reasons, but probably most importantly, it's important because we have now beefed up the programming in the state prison system, and individuals that are in the state prison system are getting markedly better programming and evidence-based programming and services. Wraparound services for mental health treatment, substance abuse and mental health, behavioral health treatment programs, re-entry services in the nature of helping them find housing and jobs and IDs that they're not going to get sitting in a county jail. And so it's important that we move them into that program so they can begin their rehabilitation and get ready for re-entry. But if you want to know about a fiscal impact that we can attribute to criminal justice reform, it's right here. And that is that in 2012, when we started criminal justice reform, Georgia spent $25 million at $21 a day paying per diems to counties to house state inmates. You understand how that works. So that per diem comes out of the state budget. If the state doesn't come and pick that inmate up, that citizen up, within a certain period of time, they have to start paying the cost associated. We all know $21 is not sufficient, but that's what the state paid. $25 million in 2012 because we've instituted electronic e-portal submission of sentencing packages. Last year, the state spent $5,760. $25 million savings that we've now been able to reinvest in programs and other services that work to help individuals and prevent them from recidivating. I usually get a couple wows on that, so thanks. Length of stay, effective PDCs, I'll just tell you that a probation detention center for a superior court judge is really a determinate sentence. If you send someone there is no parole. They have to serve the entirety of that sentence, and they're intended for short bursts. That was what they were really originally intended for, a 4 to 6 month stay. There's not a whole lot of programming at PDCs, but in the end of the day, what was happening, because some judges did not understand the methodology nor trust the parole board to let folks out when they thought they should get out, they used PDCs for permanent sentencing. So PDC times have now been capped, and that's helping us. One of the effects of criminal justice reform is when you move nonviolent, low-risk offenders out of the state prison system and you make beds available for the violent, serious violent offenders, your offender population is going to become more violent. And that's what you'll see with this, is exactly what we expected. When we started criminal justice reform, 63% of the offenders in prison were considered violent offenders. Now it's 67%. which makes you then realize how important it is that we support correctional officers and we make sure that that is a safe environment for everyone, because those beds are becoming harder. But it's exactly what we've expected. I don't have much time left. I'm going to very quickly jump on juvenile justice and just let you know that we did a couple of things in the area of juvenile justice. We all know about school to prison pipeline. My wife is a public school teacher. We recognize that some of these individuals are never going to graduate from high school, but they'll graduate from juvenile crimes to state court crimes, and ultimately, if we don't do anything about it and help them, they'll work their way into the adult criminal justice system. So we've done a couple of things. The Criminal Justice Reform Council recommended, the legislature passed a couple of bills that prohibited juvenile judges from sending status offenders to out-of-home placements. I told you the cost in the adult system. Let me tell you the cost in the juvenile system and the return on investment that Georgia's citizens were receiving. A bed in the adult system is $18,000. How much is a bed in the juvenile system per year? One bed. $90,000. 90, because we have obligations to teach and all these educational components that we don't have in the adult system. $90,000. Recidivism in the adult system is 30%. Within 3 years are back. What is the recidivism in the juvenile system? Up to 65%. Terrible return on investment. Obviously, we weren't doing everything we needed to do, and so we prohibited judges from sending truants, status offenders, to out-of-home placements. In addition, we prohibited certain misdemeanors, juveniles that have been convicted of a misdemeanor, from being sent to out-of-home placements. The challenge in a state the size of Georgia with 159 counties is, okay, divert them to what? Divert them where? If you're not going to lock them up, what are you going to do with them? And so the challenge was giving counties money to build evidence-based programs, things that we know work to reduce recidivism among juvenile offenders. What is one of the least effective tools to reduce recidivism among youthful offenders? Scared straight. It worked for me. It scares me every time I watch it, but it doesn't work. It just doesn't work very well. What does work? Cognitive programs, functional family therapy, thinking for change, moral recognition therapy. But if communities don't have the resources to build those evidence-based programs, they can divert all day long, but you have nowhere to divert these individuals to. And so what we did is the governor put $5 million together with a federal grant, $6 million in a fiscal incentive grant program, and we asked the recipients to do one thing. For a while, divert 15% of your youth from out-of-home placements. Just divert them and treat them in your community, and we're going to give you the money to build the resources. 29 recipients asked for that money. Now, these are big counties. Gwinnett, for example, is one of them, but these counties in total represented 70% of Georgia's at-risk youth. So they're huge counties. We asked them to reduce commitments by 15%. They did not, after 1 year, reduce commitments by 15%. I'm pleased to say that after the first year, they reduced commitments by 62%. In the second year, the Carl Vinson Institute at the University of Georgia has done a study, and in the second year, we are up to a 54% reduction overall in the number of youth committed to out-of-home placements. These are 29 courts, 51 counties that participated in this grant program. So we've diverted these youth. I think the number of youth is now up to about 1,200, 11 or 1,200 youth that would have been in an out-of-home placement. The likelihood of recidivating would have been 65%. And now they're being treated in a program, validated programs that have evidence-based structured cognitive programs that have been proven to reduce recidivism. I won't go through that last slide, and I think we're about out of time, so I'm going to take some questions, but tell you also a couple of other things. This year we're looking at probation in Georgia. I don't know if you know this, but let me give you one more stat that I hope I get a wow on. It's not a good wow, it's a bad wow, and that's this. In the United States, the average number of people on probation or community supervision in a community or in a state this is based on adults, not juveniles. So the number is let me get the number right, is 1,500. So for every 100,000 adult citizens in a state, roughly 1,500 are on some form of misdemeanor or felony probation supervision or parole. You with me? Georgia's number is not 1,500. Georgia's number is 6,165. We lead the nation in the number of people on community supervision. We lead the nation in the length of sentences that individuals are receiving. We lead the nation in the number of split sentences. judges that have sentenced someone to prison followed by probation, which is usually also started by a little bit of parole. And so we're taking a look at that. Taking a very hard look at the number of misdemeanors we have on community supervision, whether people that are on community supervision even ought to be involved in the criminal justice system altogether. And so ultimately we're looking at all of those things. We're taking a look at some bail reform issues too that I think you would be very interested in. I expect our work will really culminate with a report that will be generated probably by the end of January and will be made public, and you'll have an opportunity to look at it. But least you think that any of these policies are soft on crime or any of these policies are partisan, understand that almost in their entirety, every recommendation that we have made by council to the legislature has been passed, and every recommendation has been passed unanimously. Democrats and Republicans, 236 members of the House and Senate, have agreed to support the recommendations that we've made. And I think that speaks really well to the leadership of the governor. It speaks very well of the leadership that we have in the House and the Senate, that this criminal justice reform is not a partisan issue. It is a moral issue. And how you get to the table is really not as important to me as what are you going to do to contribute to resolve the problem. So what we have experienced with criminal justice reform in Georgia, and I've been all over the nation speaking about this, every other state in the nation wants to do what we've been doing. The Obama administration is trying, right here near the end of his term, to do some of this. And I've been to the Justice Department and spoken with them. This is not a partisan issue. It is an issue that was illuminated not just by Ferguson, but by other things in our country and in our state as well. The time came that we needed to take a really serious look at this. And we're not through in Georgia. I expect we'll make some recommendations this year. We will have one more year before the council expires by operation of law on December 31st of 2018. So I'm honored to be involved in it. I've been honored to have people like Rebecca, your solicitor here in Bibb County, and John Kennedy, one of your senators here in the county, and so many others. Gary Jackson has been very helpful on municipal court in Atlanta. Ben Studdard with the state court judges. It's been a very collaborative approach. And so I'm honored to be involved in it, and I think I'm now out of time and need to take some questions. Is that right?
If you don't mind, Amy, make sure you read so we get them.
So I haven't had a chance to read these and know if I know the answer, but I'll read the question. In regarding county jails, do we know how many county inmates are, I think that's there, for probation revocations for failure to pay? These revocations are often done without attorney counsel or any inquiry of defendant's ability to pay. So good point. One of the things that we've done, we've codified Bearden in Georgia. You all know you cannot lock somebody up for failure to pay if they don't have an ability to pay. Bearden said that years ago at the U.S. Supreme Court. We've codified it. We've created a misdemeanor probation bench card for all of the judges in Georgia that deal with misdemeanors. Just last year, and this just gives them guidance and helps them kind of get to the point of some of these more salient issues. But one of the things we did last year, I recommended that we no longer lock people up for failure to pay pre-trial or pre-hearing. So misdemeanors no longer in Georgia are going to be locked up waiting on a hearing to determine whether or not they can pay. They're going to get notice of a revocation, and they're going to have to come to court and explain whether they can or cannot pay. But those were changes that were made just last year. So we have made changes, which I think you'll see. It takes a while for that to get into the communities and to see the effect of it. But we've also capped the amount of time that those that commit technical violations like failure to pay and failure to report, we've capped the amount of time they can be revoked to a county jail to 4 months. Plus, because the sheriff runs the parole board at the county jails, some of these people will get credit 2, 3, and 4 to 1 credits. So we've capped the amount of time. It used to be that if you failed to pay and you got revoked, you sat in jail for a month before you had a hearing, then you got revoked and you maybe served the balance of your time, a misdemeanor sentence in the county jail. That won't be happening anymore. So good question. Thank you for your interest in that. I'm only going to grab the ones I can read. How did it become a bipartisan issue, and how can we get some more issues to evidence-based solutions? Georgia mandated by statute that the Board of Corrections now has to use evidence-based programs throughout the entire corrections system. So we're now mandating the use of evidence-based programming. I will tell you that part of our success has been because of the real changes in science and the recognition that some of these evidence-based and promising programs really do work. And so we are, to answer your point about how did this become bipartisan, You know, I don't really know. I know that the governor led with his heart on this issue. The governor really genuinely cares about this issue, and he wanted to do something about it. He pulled together this group that was bipartisan, nonpartisan, and inclusive. And, you know, it's been a remarkable example of what you can do if you don't care who gets the credit. It has been a remarkable example of political science. I was a political science major, and just watching this has been remarkable because I served in the legislature, and it's contrary to a lot of the partisan things we see on a national and state level. But it's worked very well because I think now everybody gets it. Either you get it because of the fiscal imperative or you get it because of the moral imperative, but you get it. And I will say this too, if the moral imperative alone, if just trying to remediate egregious behaviors in the criminal justice system, the way we had been doing it, based on a moral argument, which resonates with me, but if that alone was enough to fix the problem, we would have fixed it decades ago. It took a lot more than just that. In some instances, it took a fiscal imperative. In some instances, it just took getting people to sit down and understand this wasn't partisan. We're not trying to sell a liberal idea or a conservative idea. It's really about, do we want to continue to spend the money we're spending and get the same return on investment that we're getting? It's not fair to the people that we're dealing with, and it's not fair to Georgia's taxpayers. Some states have decriminalized traffic offenses. Is Georgia considering this? Yes. Next. You mentioned African Americans' recidivism rates decreased by about 23%, but you have the statistics of comparison for white men and women. I think that slide contained all of them, but yeah. So you can see the numbers for comparison purposes on commitments. In short, Caucasian commitments did not drop at near the rate that the commitments of African Americans did. What are the efforts of the council, or the council is making towards fixing the laws that place African Americans in this situation in the first place? Very good point. So, in order to fix the problem, and I've said this routinely, criminal justice reform, targeting solely the four corners of the criminal justice system, taking effect only after people are in the criminal justice system, is awful late in the process to fix the problem. This is a societal issue. It's about education reform, it's about health care reform, it's about economic reform and availability of jobs. Fixing the problem is much larger than just fixing and focusing on the criminal code. And so our challenge has been as a council is how do you come up with, you know, it's one thing to divert youth, right? What are you going to do with them? Well then, what about folks that you divert from prison but ultimately get in prison? How do we deal with re-entering them into society? I didn't spend any time on it, but Georgia has adopted a 5-year Georgia PRI, Prisoner Reentry Initiative, where we are actually making sure that individuals, when they get out, are going to transition centers closer to their home. They're getting prison in-reach services. They're getting better programming. We have hired 15 housing coordinators in Georgia to ensure that individuals that get out have housing. I mean, can you imagine getting out of prison with a unaddressed substance abuse or behavioral health issue? By the way, it doesn't get fixed just by being in prison, right? Right. So when you get out, if you still have that problem, and you will, and you don't have permanent or temporary supportive housing, you don't have any job skills that you learned in prison that are transferable to the community that you're going to, you have a criminal record that should have been sealed, or maybe you could have gotten first offender and weren't told about it. Put all of that together in a stew and none of us would succeed. So we've addressed multifaceted aspects of reentry. It's not just about giving them an ID, although we're working on that. It's not just about prison in-reach and making sure that when they get out they know where to go to get their medicals when they get out. It's not just about suspending Medicaid so that when they get out they don't have to reapply and wait 6 months, which we just passed this week. We're going to suspend it rather than terminate it. It's not just about giving them a house. It's not just about making sure that they get services in prison so that when they get out, they've got a job waiting on them. It takes all of that, and the real critical component is that if any one of those pieces of the spoke is missing, the wheel's not going to turn. It's like filling half the tire full of air. And ultimately, you've got to do it all. And what Georgia's been really smart about doing here is that we've been addressing this in a very comprehensive fashion. Not just starting with adults going into prison and juveniles that may go to prison, but then re-entry and then also the misdemeanor arena as well. So I'm being asked to, you have a slide on the percentages of black men and black women and declining commitments. Do you have incarceration data that specifically compares the number of white men jailed for drug crimes compared to the number of black men and black women compared to white men? I have it. I don't have it on this slide, and I can't really speak intelligently about it because I don't remember all of the numbers at this particular moment. But that data is available, and we, for what it tells us, it is available. And I think that's at least most of them. Was most of them. Any plans to permit person on felony probation to vote? So that hasn't been brought up really directly to the court or to the council. I will tell you that we've addressed a lot of issues that relate to this. For example, I know you all know, but there's a federal statute that provides that if you are charged and convicted of any drug offense in the United States, you have a lifetime ban on your availability to receive food stamps. Georgia, my council has recommended 3 years now running to the legislature do something about that. You can opt out. States have the ability to opt out of that, and many states have, with very limited provisions. Florida, for example, said we're going to allow convicted drug felons to receive food stamps as long as they weren't convicted of trafficking. There's all that kind of stuff. You need to be aware that Georgia did this last year, finally. So individuals that get out of prison now can receive food stamps. That implicates a lot of children of these individuals, and that is yet another cog in the wheel of trying to make sure you do a comprehensive approach. Because again, you can have a house, you can have a job, maybe you don't yet have a job. You can have all the collateral consequences of a conviction, but if you don't have food, that makes life pretty tough. And so that's part of it, but we haven't gotten into this issue of allowing convicted felons to vote. I really think that's kind of beyond the purview of what the governor has asked us to look at. We also, as I mentioned, alluded to earlier, you know that when you get Medicaid benefits in Georgia, if those are terminated, and they are if you're in prison for more than 30 days, incarcerated, you have to reapply. And that can take roughly 6 months to get reinstated. Pretty tough time, I suspect, for folks that need those services. So we recommended just this week at my council, we had a presentation on it, and we recommended that we are no longer going to terminate. This will be up to the legislature to decide. But if the legislature agrees with us, we would not terminate those Medicaid benefits, but rather would suspend them like many other states have done. So when you get out, they're simply reinstated. There's no reapplication process. So let me see what this is. Not sure I can answer this one, but I'll read it. I know drugs aren't to be justified, but why does a person receive a 15-year sentence for drugs and some sex offenders only receive a mental illness title? Really kind of outside the purview of the services that criminal justice reform is dealing with. I mean, we have 213 Superior Court judges in Georgia, all from various geographic areas. The legislature decides what sentencing ranges are, and then judges use their discretion where it's afforded to decide what is appropriate. But there's so many things. I've sentenced a lot of people to prison. I stand here today telling you that the people I sent I think needed to go to prison. Your communities were safer because of it. But ultimately, every judge has got to decide what's appropriate within the parameters that the legislature decides. Ferguson highlighted reform needs in their municipal court. Does Georgia criminal justice reform through the governor's office include any reform work or plans to address municipal courts? Yes. So I alluded to it earlier. We haven't yet gotten to it, but I do expect, and I'll just say, I should have said this at the beginning. Everything I say here is in my capacity as co-chair of the Criminal Justice Reform Council. I'm not here as a justice of the Supreme Court or just judge of the Court of Appeals. I don't express my personal opinions here. I'm trying to convey to you what the council is doing and what I expect the council may do in the future. So please keep that in mind. That said, the litigation involving Calhoun and bail reform and municipal fines and fees is something that the Criminal Justice Reform Council is taking a look at. It's complicated. I happen to serve on the National Center for State Courts, Fines, Fees, and Bail Reform National Task Force. And we've been meeting nationally to try to figure out a way, all prompted by the Ferguson report, trying to figure out the best way for all 50 states to get their arms around some of the practices in municipal courts. And so the answer, long answer now made short, is we do intend to address it. We're trying to be cautious and be careful about how we do that in light of some ongoing litigation. We don't want to waste our time, but ultimately fines and fees are complicated. You all know if an individual in Georgia gets a felony fine of $1,000, the obligation is roughly $2,000 when they get through. And if you ever look at the surcharges that are added to a fine in Georgia, I think everybody in the room, show of hands, how many think that that's probably a pretty egregious list, right? If you look at who criminal defendants are having to support by virtue of a fine, you know, who would have thought that we would have ever gotten to that point? Fines have their place, I suspect, in certain circumstances, but ultimately we're taking a look at that entire structure. I guess it would probably be fair to say that we will take probably another year to get to it in the comprehensive way that we want to get to it. There may be some bail reform this year. I don't know that there'll be a whole lot of fines and fees reform this year, because I would like to hitch that issue to decriminalization in Title 40 of some of the traffic offenses that we have in Georgia, and whether or not people that even commit a non-moving violation ought to be implicated into the criminal justice system at all, much less be on probation. So we're taking a look at all of that as well. All good questions. Thank you. Is that the last of them, Carly? Thank you all. Appreciate the opportunity.
All right, folks, it's time for our lunch break. We are on break until 12:55. Please be in your seats at 12:54. And at that time, please make sure that when you have the card, hold them up and get them for your questions.
Ladies and gentlemen, I think we have about 8 chairs per table, so if you